I'm Frank Peel with another program in my series, In Geneva, in Conversation with Frank Peel. You all remember September the 2nd, 1998. That was the day, the night, the early morning in Geneva, when Swissair SR111 went down over Canada. That had the effect of a bomb in Geneva. Geneva is a small place, and so everybody knew somebody or had family on the plane. The only thing I can compare it to was in 1963 in Geneva, when John Kennedy was assassinated, and everybody in Geneva flocked to the cathedral. Here we are 18 months later, and where do we stand with that accident? Certainly, people who didn't have family on the plane, people who didn't have some direct connection have gone on with their lives. But my guest today is somebody who has been playing a major role in the follow-up, what happened afterwards to that plane. And we're going to talk about flying in general. We're going to talk about, is flying safe? Is flying Swissair safe? My guest today is Lee Kriendler, who is the American lawyer, who is the leading aviation accident specialist, and has a very substantial number of families of victims of the Swissair SR111 accident as his clients. Lee, welcome to the show.
My pleasure.
Tell us a little bit about your role in all this, Lee, how you came into the picture, how the people found you, the families, what you're doing in seeking compensation for them, and the other things that you do. Tell us a little bit about that.
Well, okay, Frank, I'll try to be brief. Handling major air crashes is my business. This is what my firm does. We are 26 lawyers with, I believe, the largest such practice in the world. So that I come to this case with a background in handling many other cases, including major cases such as Lockerbie, Pan Am 103, Lockerbie, TWA 800, Korean Airlines, you name it.
For how many years have you been doing this, Lee? For many, many years.
My first aviation case was in 1952.
1952.
1952. So
which case was that?
That was National Airlines DC-6 on takeoff from Newark Airport. It was the third crash into Elizabeth, New Jersey, and it resulted in closing down Newark Airport. And that was the first aviation case that I had anything to do with. And a long time ago, we've had many since then.
And it's almost a half a century ago now.
Right.
And you have in your firm, you have not only lawyers, but I think you have medical people or a medical person and a full range of...
Yes, we have a medical specialist, a doctor, who is with us full-time. She's also a lawyer. We have our own aviation technical department under the management of Frank Gardner, who was with the FAA for 30 years. And Frank joined us about 14 or 15 years ago, and he...
The FAA being, for our international audience, the Federal Aviation Administration, which is the American equivalent of the Office d'Aviation civile in Switzerland.
That is correct, and we maintain our own library of aviation safety matters, whatever they are. I had handed to me just a few minutes ago a report on a major accident that happened today, and that's routine. We have files of accident reports, files on all major aircraft and so forth.
When a major accident happens, a major aviation accident, what happens as far as you're concerned?
Very shortly thereafter, in the normal course, I would receive telephone calls from family members who may be seeking information, or more usually their lawyers, business lawyers, personal lawyers, what have you, seeking information. What does this mean? What are the consequences? What happens next? That kind of thing.
And this despite the fact that the accident may happen elsewhere in the world, outside the United States, and despite the fact that it may not involve Americans. So why does it all come to you? Why does it all come to an American lawyer?
Well, not all of them do. Certainly an accident like the Swissair crash involving so many Americans, involving a flight that left Kennedy Airport, calls will come in that case. But we do have cases from all over the world. In some situations we are able to proceed in foreign accidents. Some cases we're not, but we get the calls. And in the normal course, other lawyers do too. And the families, either directly or through their own attorneys, hire lawyers, such as me. And eventually the court, there will be a meeting in court. The cases will usually be assigned to one particular court with one particular judge, and the court will convene a conference. And since major litigation, complicated litigation like this cannot be handled by 50 or 100 lawyers, the court will appoint a relatively small committee.
So Lee, you have been designated, in this case, you've been designated as the chair of the committee by the court, by the committee of lawyers.
We have a committee, a very large committee in Swissair. There are 19 lawyers, 8 of whom are partners of mine in my firm. The liaison counsel is one of my partners, and much of the responsibility and the work in Swissair is ours. All of the lawyers participate. We probably do more in terms of writing briefs and memoranda for the court.
But these are all American lawyers. There are any Swiss, and they're all plaintiffs' lawyers. They're none of the lawyers.
The lawyers on the plaintiffs' committee are all American lawyers.
Right.
There are other lawyers, Swiss lawyers, French lawyers, and so forth, who are associated with us, who, for example, have contacted us with respect to our representing their clients. So we work with those people, but they are not on the committee. In any event, that's the way it's done. Responsible lawyers do not solicit cases, do not try to attract clients. We don't do that.
There's been quite some commentary in European newspapers about lawyers going after families and so on.
That's true. It's true in particular of the Swissair. The Swissair cases, there was a parade of American lawyers up in Nova Scotia and Halifax, just utterly disgusting so far as I'm concerned. And the public is not served by that. The accident victims, the families, are not served by it. In fact, they usually end up paying fees that are much too high because the responsible lawyers, ourselves included, scale our fees to the work that needs to be done. And but that's the way it is.
Is there no code of ethics which applies in the case of lawyers like that?
And lawyers have been prosecuted for violating those ethical standards. The situation is getting better. We now have some national legislation on the subject, and there is less overt solicitation than there used to be.
Right. And what happens to a lawyer who is prosecuted for that?
Well, there have been fines imposed. The legislation is relatively new. It really began with the TWA accident, and so we only have a few years of experience, but there have been a number of prosecutions. And the word is getting around, and I think American lawyers are acting more responsibly, but still there are instances of bad conduct.
So let's talk a little bit, Lee, about the accident itself. Tell us in a nutshell what happened, what actually happened on board the plane and immediately thereafter?
Well, the accident was caused by an in-flight fire, causing considerable smoke in the cockpit. The fire, whatever its source of ignition, spread very rapidly. There was some consideration on the part of the crew as to what it should do under those circumstances, and there are some differences of opinion as to whether correct procedures were followed in terms of whether an immediate effort should have been made to approach Halifax or Boston or something and land, or whether they should fly around and dump fuel first. That kind.
And that's what they did. Did they? They flew around
Yes,
for a period.
Yes, they did, and that has been criticized. But you know, these are not only areas of routine and regulation; they're areas of judgment to some extent. And the crew was trying to save not only the passengers but their own lives. So from my standpoint, we are talking more about a fire and why it started in the first place and why it spread, and we're talking about an aircraft and systems on the aircraft that permitted that to happen, and that is the overriding concern.
Not the behavior of the crew or the reaction of the crew.
No, I think that's that conceivably could have saved the situation, but the more important question is why this thing ever started.
But if you say it conceivably could have saved the situation, doesn't that suggest that they perhaps did not do enough in making an effort to save the situation?
There were some differences of opinion on procedures, correct procedures. Swissair's procedure was not the same as Delta's procedure, for example.
In what respect do they differ?
In terms of how soon you attempted a landing.
Delta says you should immediately try and land. Is that the idea? And
in general terms, yes. That's the idea. In terms of the litigation, though, it's a debate that doesn't get us anyplace. What is more important from the standpoint of liability is how could it be that this modern aircraft, supposedly one of the best, would have such a source of ignition in the first place, and then would be literally full of insulation material, metallized mylar specifically, that would spread a fire rapidly. How can that be? Then you're getting involved in even punitive damages for maintaining a dangerous situation. Well, in any event, all of these things are explored. Lately there's been some talk about a map light in the cockpit as being a source of ignition. Of course, there was evidence found of some arcing. There's been evidence found on the accident aircraft of other arcing. I think about 20 instances of arcing. Arcing means that wires were real hot and burned through insulation and arced together, and that could have started the whole.
And that's because the insulation is
flammable.
It is flammable.
Right.
So that seems to be what, as you see it, that seems to be the base of the whole thing.
Yeah, the Canadian Transport Safety Board, which has run the investigation, and in my judgment done an admirable job, came out almost a year ago, I guess it was, damning this aspect of the aircraft. This was as close as I have ever seen to a definitive final report on an accident being issued before the final report. I've never seen one that was so definitive as this, but you could read this as a conclusion on probable cause, the probable cause being maintenance of an aircraft with such flammable insulation material that fire is going to spread rapidly.
But that was not their final report, though.
was not their final report. No, they're still working on the accident. They're still exploring.
Still working on the report.
Still exploring wire problems, so-called Kapton problems, insulation problems, metallized.
When do you expect the final report?
I don't know. The Canadian investigation has been more closed-mouthed than NTSB investigations.
That's the American investigations.
Different political flavor to it, you might say, and I don't know when we'll see.
What do you mean by different political flavor there?
They don't seem to suffer from the same compulsion to leak information on a daily basis.
The Canadians?
The Canadians don't.
They just get on with their work and do a thorough job.
Yeah, I mean, after TWA 800, to use one example, you know, you couldn't pick up the newspaper without reading some unauthorized information that had somehow come out of the investigation. So,
out of the American official investigation.
Yeah, right.
There seem to be leaks.
Right.
So when do you think we'll get the final report on SR111?
I don't know. You know, we know a lot of what we have to know already. We know there was fire. We know there was smoke. We know there was ignition. We know that there was arcing. So the rest of it is going to be very important in terms of preventing it from happening again. But we really have a good idea as to what happened.
Right now, so it seems to be the insulation here.
I think so.
And were there previous cases where this seems to have been the cause?
There's lots of recorded information referred to in the Canadian report that I mentioned a little while ago, pointing a finger at this danger.
Pointing a finger at that danger. So if this recorded information was there, then doesn't this point to negligence or worse on the part of Swissair and on the part of the manufacturer too, I suppose?
Absolutely.
The manufacturer being, in this case, being...
Well, there's a whole host of manufacturers that are involved, principally the McDonnell Douglas Corporation, which is now part of Boeing. And then you have other manufacturers, the manufacturer of the in-flight entertainment system, which is suspect as a source of ignition, and the manufacturer of the metallized mylar, the manufacturer of the Kapton wires. There are about 9 major companies that we have sued in the Swissair litigation.
Okay, let's take a break at this point, and after the break, we'll come back and see if we can flesh out more of what happened and what's going to happen, and the conclusions we can draw from it.
Get one of the TSB guys down with it. You come kneel down by the side here.
It actually looks in extremely good condition, and we're pretty optimistic the internal memory module will be intact.
I can almost smell the diesel fuel or the airplane.
Encore aujourd'hui, raconte Stephen Qu'il, chaque fois que je sens l'odeur du kérosène, je me rappelle les images de cette nuit-là. Tôt ce matin du 3 septembre 1998, Stephen Qu'il et son père repêchaient les premiers débris. Nous les avions rencontrés dans le port de Peggy's Cove.
To think that a big aircraft that size.
C'était incroyable de voir un avion de cette grandeur réduit en milliers de petites pièces, se souvient Ed Qu'il.
Lee, we talked about the fact that you are an American lawyer, and here we are in New York, and it's the American courts, the New York courts, who are involved in this, despite the fact that these accidents happen all over the world, and they happen to people who are not Americans, who've got no connection with the United States. Now, spell out just a wee bit for us why this is so, why these things can be handled in the United States, and also the question that there is a question in this case at this time as to whether or not it is appropriate for these cases to be in the New York, in the American courts.
Frank, we start with the proposition that the United States has the most sophisticated damages system in the world. That is to say that In the case of personal injury or wrongful death, American law provides more benefits than any other system of law. This goes back to our traditions of jury trial. The jury is the personification of the community, and what the jury expresses is the community standard. Well, this is more true in the United States than any place else, and what it has resulted in is public recognition of the terrible losses that are sustained in one of these airplane crashes, for example. There's appreciation and tradition here for those kind of damages. So naturally, when an accident happens, which involves not only people from the United States, but people from elsewhere, the general effort will be to bring the cases in the United States where you can recover more money. It's not unusual for recovery for the death of a child, for example, in France or Europe, UK, wherever, for that to be fairly small over there, whereas in the United States, depending on a number of variable circumstances, those recoveries can be several millions of dollars here.
Several millions in the case of a child.
It can, yeah.
What about in Switzerland? What about in Switzerland? What's the general rule?
Very small.
Very small.
Very small.
But nevertheless, Switzerland is an advanced, civilized, humane country.
Yeah, I don't want to give you the impression that every child's case is worth several millions of dollars in the United States.
Right.
But even within the United States, we have vast differences. So that in some states, such as Pennsylvania, there are so-called survival statutes where a child, when he is killed or when she is killed, can recover the loss that he or she himself or herself suffered. So if you take a child who over his life expectancy would have earned millions of dollars, you can recover that under Pennsylvania law, under Connecticut law. Not every place in the United States.
And that's more generous than New York?
Yeah. Oh yeah, definitely. And
so why is it not that all these cases have come to Pennsylvania?
Well, the cases, as you correctly point out, have been assigned to the federal court, Chief Judge Giles of the Eastern District of Pennsylvania. That's because of a wholly different phenomenon, which is convenience. You can't have these cases all over the place. New York tends to attract a lot of the cases, and in this case, the courts decided that it had enough, and so it was going to send these cases to Philadelphia for processing. So the Swissair cases, when we go to court, we go to the courthouse in Philadelphia, but those cases will probably be determined in accordance with New York law, ultimately, for the New Yorkers and so forth.
Why? But New York law, did that have any connection for the people who were not Americans, not New Yorkers, who just happened to get on the plane?
I think our courts tend generally to apply the law of domicile of the particular person. But before we get confused about that, let's assume that the cases would proceed in the United States, proceed in Philadelphia, then maybe move to New York for trial. We filed most of our cases originally in New York. That doesn't mean that the courts are going to award the same amount to a Swiss family that the Swiss family would have recovered in Switzerland. That is not the fact. The same standards may be applied as in Switzerland, but the jury reaction to those standards, the jury evaluation of the losses, will be uniquely American. So you can still recover much, much more money in the United States than you can in France or Switzerland.
In other words, it doesn't make the nationality, doesn't make any difference, or the way the Swiss or the French courts would deal with it is of no importance here.
Well, I wouldn't say it's of no importance. We do have, as you yourself mentioned a few minutes ago, we have motions to dismiss these cases based on forum nonconvenience.
Motions made by Swissair.
By Swissair and Boeing and so forth. Right. The defendants attempt to dismiss the cases here and send them back to Switzerland or send them back to France.
And those motions have not yet been decided, is that?
Motions have been made, the motions have been briefed, they have not yet been decided. We are quite confident that we will prevail in those, on those motions for a host of reasons. We think the United States has the greatest interest in this problem of any place. The airplane was made here, took off from Kennedy. About half of the people at least were from the United States. So you put all those things together, and I think the United States has the predominant interest, and I think we'll get to try all of these cases in the United States.
When do you expect, Lee, when do you expect decisions on the motions? Any idea when that will?
The court has not entertained argument yet on the motions. Our motion papers have been completed. The defendant's motion papers have been completed. We don't have a date for argument, and we really have no idea when the court will decide. But a lot of things have changed. Not only is there that question of forum nonconvenience, but the whole issue of which law is to be applied. That has blossomed forth into a new ball game. Within the last month, we have changed our law, our so-called Death on the High Seas Act law. There was always a question as to whether Swissair or even TWA 800, whether those cases would be governed by this American statute, 80-year-old statute, Death on the High Seas.
Death on the high seas. In other words, because the plane in both cases came down on water, that legislation that you have argued should apply.
We have attacked that on all levels, both on the litigation level and on the political level.
That's part of the lawyer's role here.
Definitely. No motions have been decided in Swissair, but motions have been decided on TWA 800, in which the court found in our favor and favor of the plaintiff's position, to the effect that the Death on the High Seas Act does not apply to accidents that occur in territorial waters, the territorial seas of...
Both of those accidents occurred in territorial waters.
About seven or 8 miles off the coast, essentially.
Right, and the legislation which has changed.
Well, first of all, we attacked it within the litigation. In other words, Boeing, TWA made its motion in the TWA case. That was decided by the court. It was then appealed to the Court of Appeals. We won in the district court, and we won again in the Court of Appeals. Coincident with that, we launched a major effort to change the law itself retroactively. And that has now succeeded to a very great extent, so that on April 5th, President Clinton signed this new legislation into law. And it has and will have a material effect on the TWA 800 cases and on the Swissair cases as well.
Even though both accidents occurred before the law was signed?
That's right.
The law is retroactive.
The terms of the statute provide that it will be retroactive in each case. That doesn't mean that the defendants won't contest it. The defendants very likely will contest it. But I think that we are on sound grounds on retroactivity.
Right. And what was the change that took place in the law which it means, first of all, it means that territorial waters is no longer...
It's complicated, Frank. It has a new statute was enacted which replaces the old Death on the High Seas Act. The effect of it is to very clearly eliminate the TWA accident from any Death on the High Seas Act considerations, and to modify the Death on the High Seas Act substantially with respect to the Swissair cases. To give you a very simple example of that. On the Swissair cases involving Swiss families, the standard was basically economic before, pecuniary. Now, in addition to
which means
you recover for loss of earnings, for loss of support from husband to a wife and children and so forth. The new statute signed by the President on April 5th adds loss of care, comfort, and companionship. So quite aside from money support, it will be for an American jury to determine the value of the loss of care, comfort, and companionship.
What kind of numbers are we talking about here? Give us a range, Lee, a range of numbers. It'll depend, obviously, on the circumstances of each victim. But what are the amounts likely to be, falling within what range would you say?
The large cases, the large pecuniary loss cases, that is to say, a business executive
who's earning a high salary, young age.
Yeah, 45 years old, leaves a wife and 2 children. You're probably talking about an $8, $9, $10 million case, that one individual.
Now, you mentioned that we've got the investigation by the Canadian authorities. That's advanced but not complete. And there's been changes in legislation, and you've got motions before the courts. But at the same time, there have been negotiations going on to try to wind up a number of the cases.
Yes, and there have been settlements.
Have been settlements. Many of them up to now?
No.
Not many. No. Not many. And they've been in this, of the order of magnitude that we're talking about here, those kind of figures?
Yeah, I mean, we're just now getting into the realistic process of negotiation, which is going to be very much affected by the Death on the High Seas Act changes that I've discussed, and I think will also be affected by the very strong position of the plaintiffs on the issue of forum nonconvenience.
Okay. Now, one thing which we're talking about the sums of money involved here, and another thing let's talk about, which is equally important, has been the attitudes of the Canadians, of the Swiss people, of Swissair, and of the Americans too, for that matter. I mean, obviously, to the people, the families of the victims, the friends of the victims, these are very important in helping them deal with this terrible tragedy that struck them. What's your reading? What's your feel about how these different actors here and the insurance companies?
Well, let's go down the line. So far as the investigation is concerned, it's being conducted by the Canadian Transportation Safety Board. I give the board high grades, a high grade. I think it's done an excellent job, and it's handled itself with dignity. There has not been this rush to get out unprocessed information from the investigation. The Canadians have done an excellent job.
And the rush being, you referred to that as what happened
leaking of a lot of
in the United States for the TWA accident.
Yeah.
So, right. So that's the Canadian authorities. High marks.
Yes.
What about the Canadian people, the people in the area?
Canadian people have been wonderful. The families are all deeply appreciative of their kindness and solicitude, recognition of the terrible losses that the families have suffered. So the Canada gets high marks. So far as some of the defendants are concerned, Swissair, I think, has tried to act very responsibly, made some mistakes in the early stages. There were advances made, and it was not handled too wisely by Swissair, because
advances made and money advances to the families.
Yeah, for example, an advance of 100,000 SDRs, special drawing rights, which equates to about 135,000 American dollars. In the early stages, that was said to be for the whole family. So if there were two decedents, two children killed, the first effort was to give half for each of the children. That was very foolish.
And the Swissair tried to get people to waive their rights?
Well, I don't think it was malicious. I think it was more a matter of an interpretation. But that was changed rather quickly. To Swissair's credit, it was changed so that all decedents were dealt with the same way.
And wasn't there also a period, maybe a brief period, when Swissair was dealing with European families and American families in a different way?
Yes, well, that's the same.
The same thing.
That's the same area that we're talking about. But Swissair made no bones about it. It wanted the cases settled, and it wanted the cases settled quickly. And I think that's to the good. The Swissair management statements was not matched by the conduct of Swissair in the litigation. And here we get into a rather complex area because the shots are called not by the airline, but by the insurers for the airline. So when Swissair refused to settle for certain sums of money, it really was more the insurance company taking the position than it was Swissair. In fact, several Swissair lawyers who I met at international conferences and so forth expressed regret to me that on the firing line, the amounts were not being offered that Swissair might want.
But this is not just Swissair. This is presumably the manufacturers of the plane and the manufacturers of the plastic also. They're all involved, are they?
That's correct.
Yeah.
There is a bit of a tussle now as to who should have ultimate claims control. For example, as a result of the Swissair accident, partly, IATA, the airline association, a couple of times took a public position that it should revert to the airlines, that the airlines should be making claims decisions rather than the insurers. That with the insurers involved, it had more of a commercial tone to it, and they weren't moving the money fast enough to the people who were entitled to it. But we'll have to see how that plays out.
But that doesn't sound to me very practical in the sense that the insurance company, if you carry that too far, then the insurance companies will be refusing to pay Swissair or whatever.
Well, all things are going to happen if the insurance industry doesn't follow through on what the airlines want. Then it fundamentally is within the power of the airlines to get new insurers. And I don't think this story is concluded yet. From what I hear, there's considerable dissension out there. Some airline people I know feel that the insurers are not being realistic for this day and age, and we'll just have to see what happens.
The insurers are not living up to their insurance obligations, is what you're saying. Lee, let's talk a little bit about the way lawyers are compensated in the United States, which I believe is different from the Swiss and the European practice. Although, if I'm not mistaken, the Swiss and the European practice may be changing a bit and may, in any event, not in the past not have been unrelated. The compensation received by lawyers not have been unrelated to the results which are obtained. Give us a little bit of the background on the way your compensation works.
Our compensation, that is to say, the compensation of American lawyers is based on a contingent fee. You're quite right about that. Lawyers differ as to what they charge. When Swissair came along, we looked at the realities of the Swissair case. Swissair was a very interesting case for me in particular, because I had taken a very active role in trying to change claims practices by airlines and insurers. And to simplify it, a major change had occurred before Swissair. Swissair was really the first major accident where we had something called the intercarrier agreement, the IATA intercarrier agreement, in which the carriers, the airlines, waived several of their defenses under the Warsaw Convention. Now, I'm sure this sounds like Greek to you, but the bottom line is that either as an historical accident or responsive to many things that, many criticisms that had been leveled against limiting damages, so-called Warsaw Convention, limitations of damages, for whatever reason. When Swissair came along, there was in place this agreement signed by Swissair, signed by Delta, signed by most of the airlines, in which they had agreed to waive the limit. The practical limit had been $75,000 a person. Well, in our firm, as soon as this happened, I convened a meeting of our partners, and I said, I think we cannot look at this case the way we've looked at cases in the past. There's a difference because the passengers are going to recover more money here, and there is responsibility on the part of the airlines. Article 17 of the Warsaw Convention still exists, and it says the carrier shall be liable. And Article 22 of the convention, which limited that liability, had been waived. So I said, gentlemen, we're now sitting with a case where the passengers are going to recover. This is a different kind of a case. Our role is more limited in a sense. We know that we're going to win. Now, we always expected to win, but we have to charge lower fees. And so, as a matter of policy in my firm, we did that. We reduced our net fees to Kriendler and Kriendler office to 15% contingent fee.
15% of the amount recovered.
Yeah, 15.
And if nothing is recovered, you receive nothing.
Well, something is going to be recovered because the nature of the liability system is such that we don't have to worry about a limitation, and Article 17 says the carrier is liable, so something will be recovered. But the fees in other cases in the past have been higher, 20%, 25%. The usual fee in accident cases in the United States used to be 33 1/3%. But we felt that this was the responsible thing to do, and it was realistic, and we could afford to do it. So that became our policy. Now, many clients like to have their own lawyer involved in a case, and we welcome that. We enjoy working with other lawyers, and what happens simply is that a fee is then provided for the personal lawyer, which is superimposed on our 15% fee. But this is the situation in all of our Swissair cases.
Now Europeans say that this contingent arrangement, these contingent arrangements, encourage litigation, and they give because they give the lawyer an interest in the result, that it's not desirable. No, what's your answer to that?
It just simply isn't so. I think the contingent fee provides a discipline which is in the public interest. For example, case comes along which I don't think has merit. I'm not going to take the case because I don't get paid unless I perform. If the fees are reasonable, as I think they are, for example, in our Swissair cases, there's no way a lay client can possibly accumulate the knowledge to know whether a case is a $100,000 case or $10 million case. And that learning and expertise, which is well developed, and we spent a great deal of time. I mean, we've been to Switzerland countless times talking to our clients. It all takes a lot of time. The fees are reasonable.
So you're saying, Lee, that if a case comes along which is without merit, you're going to say you won't take it. Whereas if the fee arrangement is not a contingent one, then and the lawyer says, well, I don't think the case has any merit, but it's going to cost you 10,000 francs if you want me to take it on. You're saying
that encourages litigation.
That encourages litigation, and that encourages people to throw their money away, I guess is what you're saying.
Right. Yeah, I think we've come up with a formula that provides for fair compensation for the work done. And as a practical matter, there's no other way that people in this position can afford the best lawyers. There's a lot of work in one of these cases.
Lee, let's finish up now. Let's try and sum up. Let's try and draw a few conclusions from this. We've had a terrible accident. We're looking at the future where there are going to be more planes flying, more accidents, presumably more accidents, and the air control systems, which are a big issue in Europe too. Do you think? Do you fly? Do you worry when you fly? Is flying safe? Is Swissair safe?
I'm a comfortable flyer. I might on occasion have a gin and tonic or something to ease more, I wouldn't say fear, but the tension of the thing. I think flying is wonderfully safe. I'm a great
Wonderfully
exponent.
safe.
Wonderfully safe.
Including Swissair.
Including Swissair, generally speaking. Swissair accident is a great misfortune, great tragedy for Swissair as well as for the families. It's an aberration. It's an aberration. The system is still good. There's a lot wrong with it. There's a lot wrong with it. We can make it much better. The investigation into Swissair has already made the MD-11 a safer airplane, and it's made other aircraft safer too, because there's now a timeline on metallized mylar. We're getting rid of that stuff, so it will be improved as we go along. But I'm a very comfortable flyer. I'm in an airplane every week, and with my family much of the time, and I don't worry about it.
When you go to Switzerland, you fly Swissair?
Yes, I have flown Swissair. It depends. There are other ways of getting to Geneva. If I'm in a real hurry and I've got 4 or 5 stops to make and I have to be in court on Tuesday afternoon, I might fly the Concorde to Paris or London with
But your choice does not depend on safety, does that? No. Lee Kriendler, thank you very much for this very, very interesting talk. 2 last remarks to make. First of all, some considerable months ago, I invited Jeffrey Katz, who is the CEO, the president and CEO of Swissair, and is himself American, and therefore completely Anglophone. I invited him on my show, but I was told no, he didn't have time. I wanted to be fair, and I'd like now, Jeffrey, to renew this invitation. If you feel, if you feel that there's something in this program that needs to be answered, or if you just like to appear to talk about Swissair and talk about Swissair's future and so on, fine, let me know. I'd be delighted. My next show is on Friday the 2nd of June, and as usual, the Thursday morning after that. My next show is about new blood in the United Nations system, new blood in the form of Mark Malloch Brown, who is the administrator of the UN Development Program. This is Frank Peel. Good night and bonne continuation.